This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon, Council. On behalf of Judges McBrayer and Davis, we're happy to have you here. This will be conducted just like any other court session that we have, as if we were in person. If there are any technical glitches, we will stop and fix them. If nobody has anything to say here, we'll just get started. Mr. Hivner, would you please call the case?
Flora Setayesh versus State of Tennessee.
Okay, is the appellant ready?
Yes, Your Honors.
Okay.
Good afternoon, Your Honors. May it please the court. My name is Garrett Englund, and I represent the appellant Flora Setayesh. This appeal centers around the interpretation of a special condition in appellant's contract of employment with Nashville State Community College, in which she was appointed as an administrator with the school from her position as a tenured professor. The special condition in this contract states expressly, both parties acknowledge that TBR policy governing tenure and salary conversion supersedes all language associated by this contract. Both parties to the contract, Dr. Setayesh on behalf of herself and Dr. George Van Allen, who was president of Nashville State at the time, agree that the language TBR policy governing salary conversion references a policy called the 80% rule. This rule states that when an administrative appointee converts back to a faculty position, the conversion from a fiscal year contract to an academic year contract will occur at no less than 80% of their base fiscal year salary. Upon Dr. Setayesh's return to faculty, the TBR refused to honor her contract and offered her a salary that was much lower than the 80% minimum to which she was entitled. The primary issue before the court, appellant submits, is that the trial court erred in concluding that her contract was clear and unambiguous, and thereby erred in disallowing parole evidence that would aid in interpreting the language of her contract, specifically this special condition. This evidence includes the past practices of the state in applying the 80% rule, but most importantly, it includes the testimony of the two parties to the contract themselves. If this court deems that evidence admissible, said evidence warrants a reversal of the trial court's decision and warrants a determination that Dr. Setayesh should have received a minimum 80% of her base fiscal year salary upon her return to faculty. First, the trial court concluded that since the language at issue in this matter was clear and unambiguous, Dr. Setayesh's contract should be interpreted based on its written language only, without resort to extrinsic evidence. The trial court thus applied a strict textual approach to the interpretation of the contract. However, the Supreme Court in 2019 made clear that Tennessee cases have largely eschewed an extreme textual approach to contracts in favor of a more balanced approach. The courts demonstrate a focus on the written words in the contract, but they also consider evidence related to the situation of the parties and the circumstances of the transaction in interpreting those words. The cardinal rule in contract interpretation, according to the courts, is that courts must ascertain.
Just for clarification, factually, the 80% rule or policy, that's not a written policy, correct?
We would contend that that is not a written policy. It is a practice of the school that has occurred over the last 20 years at Nashville State and with the TBR. Okay. Yes, Your Honor.
I thought it was in the general personnel rules policy.
In the trial, our testimony between Dr. Van Allen and Dr. Setayesh was that the TBR had instructed Dr. Van Allen to follow this rule since 2001, which actually began when he tried to convert a department chairman back to faculty at 75% of his administrative salary. At that time, the TBR informed Dr. Van Allen and his administration that it was imperative that he follow the 80% rule. From that point forward, it was known within the institutional vernacular that when somebody was converting from administration to faculty, that they would be converted at 80% of their administrative salary.
The 80% rule is written in the general personnel policy, correct?
It is not. It is not written in the general personnel policy.
Well, what is, okay. Well, what is section 4K?
Section 4K was related to temporary appointments, as has
Well,
been.
it says it's related to temporary employments.
It does. 4K does talk about temporary appointments. However,
Where does it say that?
in 4K, it does not specifically state in 4K. I believe this was inferred by the court based on 4I through K. And at the time of the trial court's order, I believe if you look in 4I, J, and K, the trial court essentially grouped these together. And
Right.
that,
Why?
well,
I don't see any reason that K just limits I and J. Enlighten me.
yes, Your Honor. Actually, we would tend to agree that K should not be limited by I and J. We had submitted, based on the testimony from the record, that Dr. Van Allen's application of the 80% rule was based on his instruction to do so. However, if you look at 4K, it does not mention temporary appointments. It only mentions that when somebody is converted back to an academic year contract, my apologies, that it would be converted at 80%.
And in fact, people go back and forth between both permanent and temporary administrative positions and faculty positions all the time, don't they?
I would tend to say that they do if they based on what's necessary at the time. Yes, Your Honor. And especially in a situation where somebody is in a temporary appointment and then is promoted to a permanent administrative appointment, of course, the circumstances might change. And
it strikes me your argument is more akin to mistake. You're saying that there was a mutual mistake made by your client and Dr. Van Allen in understanding what that clause meant, not an ambiguity. Unfortunately, for your position, Dr. Van Allen is not the contracting party. So it really doesn't matter if he made a mistake, does it?
Well, Your Honor, the appellant would submit that Dr. Van Allen was the president of Nashville State Community College at the time that he entered into the contract and signed the contract on behalf of Nashville State with Dr. Setayesh. Dr. Setayesh and Dr. Van Allen actually agree as to what that contract provision means. So when they both signed the contract, they discussed this provision and decided between themselves at the time that they signed the contract that they would include this special condition referencing the TBR salary conversion policy, which they both understood at the time in 2014 and 2015 to be referencing the 80% rule.
But I guess the sum of your argument is really it would have been better had the agreement referenced an unwritten practice or a practice of the school to convert salary in the way this 80% is sort of akin to the way the 80% rule is handled under the general policy under 5.01.
Well, the appellant would submit, Your Honor, that the contract doesn't specify whether it's referencing an unwritten policy or a written policy. So the sort of base argument that the appellant is making is that parole evidence should have been considered by the court, including the testimony of the two parties to the contract, to understand exactly what was being referenced, because it doesn't specify. So it doesn't specify that it's referencing 5.01. It doesn't specify that it's referencing an unwritten policy. And we have to rely on the testimony of the two parties to the contract to understand what's being referenced. And the main consideration here, Your Honors, is that we have to understand what the intent of the contracting parties was at the time that the contract was entered. And the simple fact is that both Dr. Setayesh and Dr. Van Allen in their testimony testified that they understood that this salary conversion policy referenced the 80% rule, and that said rule was intended to be a binding term of their agreement. In fact, they negotiated this provision in 2014 and in 2015 when both of these contracts were signed, even though the 2015 contract is the one that we are dealing with. Furthermore, Dr. Van Allen, as we've stated, was actually instructed to follow this rule for 20 years during his tenure as president of Nashville State. beginning in 2001 with Ted Washington, the department chairman, in 2008 with Judy Kane, and again, actually in 2014 with an employee named Jennifer Knapp, who actually held a position as Associate Vice President of Academic Affairs, which in fact is the same position that Dr. Setayesh took after Jennifer Knapp transferred back to faculty at a rate of 85% of her fiscal year salary. The other consideration and the most important consideration is in allowing this evidence, we have to determine whether this violates the parole evidence rule. It does not, because the testimony does not contradict any of the written terms of the agreement. The contract simply references TBR policy governing salary conversion. The two parties to the contract, Dr. Setayesh and Dr. Van Allen, have simply explained in their testimony what that salary conversion policy is, because the contract does not specify exactly what is being referenced. As such, the admission of this evidence would not add to, contradict, or vary the written terms, but simply clarify those terms. Furthermore, even if we embrace the trial court's textual approach, the court's conclusion of law in regard to this is still an error. The trial court concludes that the language unambiguously references this TBR General Personnel Policy 5.01, specifically Section 4I through K. However, the trial court's conclusion is unsubstantiated by any explicit language in the contract. The contract provision doesn't state what is being referenced by this TBR policy governing salary conversion, but it does reference policies outside of itself, which thereby undermines a four corners determination of the contract and an interpretation. Therefore,
I'm sorry, I don't understand what you just said at all.
Yes, Your Honor. The contract language does not actually reference any of the policies that the trial court relies on in making its determination at the trial court level. It doesn't.
Well, obviously, it's referencing something, and isn't General Personnel Policy 4K there? Isn't that clearly what they're talking about?
Well, we would submit, Your Honor, that the party's testimony must be considered by the court and admitted in order to understand what this policy is actually referencing.
Well, is there another policy that somebody's pointed out that refers to people transferring back to faculty positions and what their pay should be? I didn't see anybody reference another policy in the briefs or pleadings.
The parties, we would submit, Your Honor, that the parties, Dr. Setayesh and Dr. Van Allen, were referencing the 80% rule as was instructed to Dr. Van Allen to apply during his 20 years as president.
Right. And where is that rule? It's in 4K. I don't understand what the big ambiguity is. I don't understand why you need parole evidence here. They're saying we want to go by this special condition and clearly referencing what is the 80% rule in the personnel policy. What's the big deal?
The main issue is that the understanding that Dr. Van Allen had of this rule may not have been explicitly referenced in this general personnel policy in the entire 20 years in which it was applied. So the only version that we have is of this policy as
how
it is
so?
I can't be sure because I don't know of the previous versions of the policy, but mainly Dr. Van Allen.
Then what you're saying doesn't really matter about this, is what I'm hearing, because you don't really know.
Well, Your Honor, Dr.
Your
Van Allen.
time's up. Your time's up.
Thank you, Your Honor.
Appellee.
Good afternoon, Your Honors. John Dalton with the Office of the Attorney General for the Appellee Defendant, the State of Tennessee. The contracted issue in this matter is a two-page employment agreement of 8 paragraphs. It is not a complex agreement, and the appellee submits that the trial court was correct in determining that the contract was not ambiguous, and as such, there was no need to consider the parole evidence offered by the claimant at trial. The contract was entered into by, of course, Dr. Setayesh and the college, and the evidence at trial indicated that Dr. Setayesh did have the ability to influence the language within that contract. That's why there are two versions of it. The second version includes additional language in paragraph 6 at the request of Dr. Setayesh. And that was added at her request, and that is why that happened. So she had the ability to affect the contract, and it had the language that they wanted in that.
So what does the special condition refer to?
It's not specific as to what it refers to.
So it's ambiguous.
Pardon?
So you would agree then that it's ambiguous?
I would not agree that it's ambiguous as to the intent of the contract. The language is quite plain, actually. And that was the finding of the trial court that it was.
And I'm gonna take a bit of a different tack than Mr. Anglin had with Judge Bennett. But it says both parties acknowledge that TBR policy governing tenure and salary conversion supersede all language associated by this contract. Now, we all agree that Mr. Anglin's client and apparently the president believed that that policy was referring to the 80% rule. That's what they believe, correct?
That was their testimony.
And it's your contention that no, what said when it used the term TBR policy, it was referring to policy 5.01.
Yes, correct. And that was the analysis of the trial court. The trial court analyzed the policy and found that because it was a transition from a permanent administrative position rather than a temporary administrative position, that particular provision was not applicable to Dr. Setayesh because she was in a permanent position when she transitioned back to faculty.
Does the TBR agree, or did it agree with the Claims Commission that the 80% policy was in fact an unwritten policy that was utilized, or do you guys not even get into that because parole evidence?
I don't believe we got into that. I don't believe the record reflects that.
Okay.
So how do you get that it's a temporary, only applies to temporary positions?
If you read the provisions of the policy in conjunction, as the trial court did, it reflects that it refers to temporary positions. There's a discussion in there that if it's a temporary position, then there is a stipend attached to that. And because Dr. Setayesh's position was not temporary, it was a permanent position, there was no discussion of stipends. And that's part of the policy also that was analyzed by the court in determining that it was applicable. The so-called 80% figure was applicable if it was someone transitioning from a temporary position back into faculty rather than a permanent position of the sort that Dr. Setayesh had.
So you think the language about administrative stipend means that it's just a temporary position?
Correct. If you read the provisions in conjunction, yes, that's
Are you
part of.
talking about I, J, and K?
Yes, correct.
You're saying
yes.
these-
Yes, if they're read in conjunction, yes, that was the analysis of the trial court, and that's how the trial court determined that because that was referring to temporary positions returning to faculty, that it was not applicable to Dr. Setayesh, who was in a permanent position. I think it's also worth noting that because Dr. Setayesh had the ability to influence the language of the contract, Dr. Van Allen agreed or testified at trial that the 80% language could have been explicitly included within the contract. It was not in there. It simply was not there. And
well, to that end, so could you all have put, or the TBR have put specific reference to policy 5.01? I mean, that goes both ways, doesn't it?
Well, the contract does not numerically specify applicable TBR policies. It just says TBR policies in general.
No,
With the personnel policy, of course, being one of them.
It doesn't say a policy or the policy governing tenure and salary conversion. It just says TBR policy.
That is correct. That's what the language says. Yes.
All right.
So,
Is there another TBR policy?
oh, there are other TBR policies. I don't believe there would be any other TBR policies that would be applicable to this situation. other than the personnel policy, which is the one that we're discussing.
And there's no other 80% policy but this one, right?
I'm not aware of any other 80% policy. No.
Okay.
And so it is the appellee's position that the trial court was correct in determining that the contracted issue was not ambiguous, and therefore the court did not consider the parole evidence offered in reaching its decision. I would also like to speak to the one area where the trial court did make an award, which referenced when Dr. Setayesh returned to faculty in the spring of 2018. She returned in the middle of the spring semester, or with the semester already underway. And it was the testimony of the payroll manager for the college that in determining how to pay her for the rest of that semester, that she determined how many working days were left in that academic semester. And there was 38.8% of the semester left. She looked at the working days left in that semester and she paid her accordingly. It is our contention that the trial court, in awarding additional funds for that semester, was in error on that, because the trial court's calculation would have been correct if we were talking about a 12-month working year. But for faculty, that is not correct. It is a 9-month working year. And so that's how the college made that calculation. We would submit that the college was correct in paying Dr. Setayesh for spring 2018, and that the trial court was in fact in error in awarding additional monies for that time. It is undisputed that Dr. Setayesh did testify at trial that she did not work the summer of 2018, although she states otherwise in her brief, but the testimony was she did not work that summer. Had she worked the summer of 2018, then additional compensation would have been owed to her, but that is not the case. She didn't work that summer, and it is our contention that the college was correct in calculating what she was paid for the remainder of the spring 2018 semester. And we would say that the trial court was in error in awarding the additional funds, and ask that portion of the trial judgment be reversed. That, I believe, concludes my main comments. If the court has any further questions, I will certainly endeavor to answer them.
I don't see any. Thank you, Mr. Dalton. Mr. Anglin?
Thank you.
Thank you, Your Honors. Just to follow up on some of the questions that Your Honors had previously, appellant would submit that either the contract policy, the CBR salary conversion policy, could be referencing an unwritten policy that was the 80% rule, as Dr. Van Allen testified, or it could be referencing a general personnel policy 5.01. In either situation, both parties intended for the 80% rule to be applicable to Dr. Setayesh upon her return to faculty. That was the intent of the parties in adding the language to the contract. It was a special condition that was included in the contract by the parties. It would make no sense for the parties to include a special condition that was inapplicable to them, or that was inapplicable to Dr. Setayesh. It was clear based on their testimony that they intended for this 80% rule to be applicable and wanted it to be a binding term of the agreement. I would also follow up with the statement that Dr. Van Allen's and Dr. Setayesh's testimony was also backed up by these past practices. And I understand that that it could be referencing the general personnel policy, but the fact that the TBR in Nashville State had a history of applying this 80% rule is evidence for how it should be interpreted. It's evidence for what was meant by the inclusion of this terminology, because of how the custom and practice had been administered for 20 years when Dr. Van Allen was president of the school. And just briefly, I would like to address Mr. Dalton's arguments with regard to the last part, with regard to Dr. Setayesh's salary for the remainder of the spring 2018 semester. Appellant would submit that Dr. Setayesh's salary in her contract was shown to be $89,700. This salary is paid out over 12 months for a 9-month contract, which means that $89,700 is divided by 12 to make for $7,475 per month. That per month amount appellant submits should have been proportionally divided over 4 months and 23 days of the year, which is the total amount of time that Dr. Setayesh worked for the remaining portion of the 2018 semester, from the last week of March through the second week of August. That includes 4 months of April, June, July, April, June, July, and August, and then at the end of March. And according to Dr. Setayesh's calculation, she would have also been accorded a 10% retirement pension, which would have been based on the total amount, which would have totaled $1,821.90. With that, we would say that actually the amount that Dr. Setayesh was owed should have been increased and not decreased.
Okay, thank you, gentlemen. Mr. Hivner, would you please recess court until tomorrow morning?
Mr. Honor, this honorable court is now in recess until 9 a.m. tomorrow.